Hey, good evening, everyone. Good to see you all again. So, a few announcements. Once again, a reminder that I have been asked to sit down. I usually walk around, but because of the recording purposes and the mic. Okay, so that's why I will be sitting down. I just want to get that out. I don't usually sit down to teach. Secondly, I will be giving a break. Today is a 3.5 hour session, right? So we've got 3.5 today, 3.5 tomorrow, and then 3 on Thursday. So I will give a break at 8:30, 10 minutes, and then one more at 9:30, right? That's the break schedule. I mean, it'll be roughly around there. I will also cater for if there's a break in the teaching, an appropriate place that is around that time, then I will give the break then, right? So what we're going to do this session today, tomorrow, and Thursday is one chapter, which is easements, right? Easements is I will say, a little bit of a tricky chapter, in my opinion, right? It can be a little bit confusing. It can be yeah, I mean, I'm gonna show you what I mean, right? It's a little bit tricky, but very doable, right? It is highly likely to be a problem question chapter, right? I mean, this is a chapter that it is very likely that it's going to be a problem question. Now, that's not to say that there's not been essay questions, but the essay question that has come out is like, from what I've seen, like maybe once in the past 15 years, right? That kind of a thing, once or twice in the past 15 years. It is an overwhelmingly likely to be problem question chapter, right? So if you are someone that prefers problem questions, this is one of those chapters where very, very likely to be problem question, right? Another one of those chapters is freehold covenants, right? Very likely to be problem questions. I mean, again, there can be essay questions for covenants. Have you all done covenants? Have you done? You've done covenants, right? Maybe not with me, with someone else. But if you've done covenants, you will see that there are the possibility of essay questions, but it's only the kind of essay question that can come out is only one type, the reform. But for easements, it's even less chance of an essay. So it's a problem question area. The struggle with easements is the fact that a lot of the possible answers kind of look very similar to each other. So no point explaining it now. I will go through the chapter first and then you'll see what I mean. But that's what it is, right? It's a situation where if you are not 100% confident about the subject matter, the possible answers can look very similar to each other and it can be confusing, right? That's why I say it's a little bit tricky, right? Is it case law heavy? No, it's not a case law heavy type of topic, in my opinion. That might be something exciting for some of you, right? It's not a case law heavy chapter. So what is a case law heavy chapter? In my opinion, co-ownership, proprietary estoppel, lots of cases. And you need to know those cases. Adverse possession, case law heavy, right? But I think easements and all is more application of the law, right? Okay, so what is an easement, right? So we've seen easements are not a new word for you. You've seen easements when we studied chapter 1. What is an easement? An easement is a right on someone else's land. Anyway, maybe you can just get out the notes that I've given you. You should have received an email with a few handouts. One of it is called the Easements Crash Course. That's the document that we're going to be using today, definitely, and it will spill over to tomorrow. I don't expect the lecture it cannot finish today, right? It'll definitely spill over tomorrow. And then once it's over, as usual, whenever I am assigned one chapter only for 10 hours, once we finish the lecture, we'll just keep doing questions. So I've also sent to you at least 4 sort of suggested answers, correct, right? At least 4 I've sent. If we go through all 4, we will pick up more questions and we will do it. right? That's how I plan to finish the 10 hours that we have with you, right? Okay, so coming back to this. So what is an easement first? Before we look at these notes, just leave the notes there, right? What is an easement? So from your study of chapter 1, which is likely to be the last time that you saw easements, right? An easement is a limited right that someone has over someone else's land. So I repeat that, a limited right that someone has over someone else's land. Later we will see if the right is something like you can do whatever you want, however you want, whenever you want, that cannot be an easement. So that's why I use the term a limited right, right? It is a limited right. But when I say limited right, I don't mean that there's only certain things you can do. So easements can be a huge variety of things, right? You can have a right of way. A right of way means you can walk over your neighbor's land. You can drive over your neighbor's land, right? And easements are very specific, guys. We're gonna learn that. So if you have the right to walk over your neighbor's land, if you have the right to walk over your neighbor's land, that does not mean you have the right to drive over your neighbor's land. Right? So easements are very, very specific. Easements need to be very, very clear. So just because you have a right of way, the right of way is not a free for all. The right of way is not a situation where, just because I have a right of way, I can do whatever I want. It's very specific. So it's specific to the point where if you have the right to, let's say, walk across the park, someone has given you an easement to walk across the park, but then now you take a group of your friends, 10 of your friends, and you decide to do jogging across the park, that is breaching the easement already. You may not have that right. Why? I mean, understandably, logically, an easement is a right over someone else's land, isn't it? So it must be very specific and it must be very clear as to the extent of that right. The reason is because you are a third party over having a right over someone else's land. If that someone else wants to sell the land, if that someone else, your neighbor, let's say, or whoever owns the land, he wants to sell the land, the purchaser must know what exactly you can do on the land, correct? If not, means if he wants to buy the land, he must know with sufficient clarity what exactly right you have on the land. That is why you will see a great importance is placed on the specific nature of the right. Okay, so that's the first thing you need to understand, right? It is a limited right over someone else's land. Okay, now this easement, as we studied in chapter 1, can be created expressly. That one is the simple stuff. So if you are the owner of the land, you give me an easement, I have an easement, full stop. Can I ask how to create an easement? Cannot, huh? Okay, I won't. But you should know that this is what you studied in chapter 1, right? How do you create an easement? Anyone want to hazard a guess? Yes. See, chances are if you just say the word deed, you're probably correct. But that's not a full answer though. It's a lot more complex than that. Deed is there. Deed is maybe 40% of the answer, 50% of the answer. What else? Registration. So deed plus registration. And that is to create what type of easement? Who said legal? Legal. Legal easements. How many? So an easement can be legal or equitable. Okay, now I'm going to ask a really irritating question. How you know that an easement can be legal or equitable? Okay, that's a terrible question, because the answer could be, of course I know. Okay, which law, where does it say that an easement can be legal or equitable? Let's do a bit of revision. LPA, very good. Section? Brilliant. Section 1 sub 2. What does 1 sub 1 say? 1 sub 1 says two types of estates. And then 1 sub 2 and 1 sub 3 talk about interest. And 1 sub 2 says the rights that are capable of being legal, interests that are capable of being legal come under 1 sub 2. And then 1 sub 3 says all other interests are equitable. Very good. Very good. Very good. Not too bad. Right? Of course, those of you that are sitting there and got no clue what I'm talking about, you need to fix that, huh? Right? We are nearing the end of the syllabus already. Correct? So that is 1 sub 1, 1 sub 2, 1 sub 3 of the LPA 1925. Remember, these are the building blocks, the ABCs of property law. Right? So 1 sub 2 says there are certain rights that are capable of being legal, and ladies and gentlemen, an easement is one of them. What are the others? Just for fun, huh? Just to irritate. You've got easements, then you've got leases and mortgages. For the purposes of your syllabus, these three is enough. Right? Easement, leases, mortgages. So remember, when you're right or when the interest is a 1 sub 2 interest, it doesn't mean that it is always legal. It means it is capable of being legal. And when does it become legal? When the formalities of creation have been complied with. When the formalities of creation have been complied with. And what are the formalities of creation? And again, it's individual, right? So what are the formalities of creation for an easement? The answer is a deed plus registration. A deed plus registration. Who tells us that? Again, who tells us that? Which law tells us that? Section 27 of the LRA 2002. Section 27 of the LRA 2002 says that if you want to create a legal easement, deed plus registration. Okay, good, huh? A little bit of revision, right? Now, why am I saying that? Because coming back to the story of easements, right? So an easement is a limited right over land. So the landowner can give you that right, right? The landowner can give you that right. He can give it to you expressly. So if he gives it to you expressly means he creates the interest by deed, and then there is also registration onto the title. Then what you have is a legal easement. But let's say one of those things are not done, or both are not done, but it is at least in writing, according to section 2 of the LPMPA, remember? Then what do you get? You get an equitable easement. These two, ladies and gentlemen, what I just described is how easements are expressly created. I repeat that. Huh? What I just described is how easements are expressly created. That means I want to create an easement for you. Okay. Having spent all that time, in this chapter, expressly created easements are almost never going to be tested. Expressly created easements are never going to be tested in this chapter. I mean, it's too easy, isn't it? So what are they going to test you in this chapter? So when we studied chapter 1, I would have hinted at this. Not hinted, I would have clearly said that easements can be impliedly created. But remember, I would have said, don't worry about it. When we study easements, we will learn about it. That's where we are today. So ladies and gentlemen, in this chapter, we are going to be learning primarily how easements are created. Of course, we will learn about how they are expressly created, but that is done already. The past 5 minutes, done. That's it. But easements can also be impliedly created. Impliedly created meaning The landowner didn't actually give you the interest, the easement. The landowner didn't actually give you the easement, but you are going to court and you are claiming that you should get that easement. You are claiming that the easement is impliedly created based on circumstances. And ladies and gentlemen, what we're going to be learning is those circumstances, right? So this chapter is effectively divided into two, right? The chapter is divided into two. The first half of the chapter is that right an easement? So remember, I gave you some examples of easements, right? The right to walk across your neighbor's land, the right to park your car in his garage, the right to store your things in his storage room, the right to put your TV aerial. Who has a TV aerial anymore nowadays? Huh? But for example, to put your satellite dish on your neighbor's roof because there's better reception. All these are easements. Underground piping, right? So your sewage piping, right? When it comes out of your house, all your bathrooms and all of that, the one pipe comes out, but the pipe cannot just end under your house, isn't it? It needs to go to somewhere where they collect the sewage. That pipe probably needs to go under someone else's house. That's an easement. You see what I mean? So all these easements, right? Just because I have told you that these are possible easements, the next time you see someone parking your car, someone parking his car in his neighbor's garage, it doesn't automatically mean it's an easement. Just because you are swimming in your neighbor's swimming pool doesn't automatically mean that's an easement. There are preconditions. There are several essential characteristics of an easement. So, ladies and gentlemen, the first half of this chapter is the essential characteristics of an easement. Right? So, if you like, this duster, the first half of the chapter is this a duster? Just because it looks like a duster, just because it works like a duster, it doesn't automatically mean it's a duster. It needs to satisfy the prerequisites. So the first half of the chapter is this a duster? The second half of the chapter is this duster mine? I'm making a claim for this duster. Is this duster mine? So forget the duster, easements. The first half of the chapter is it an easement? It may look like an easement generally, but it may not be. And then the second half of the chapter is the person who is claiming for that easement. Does he get it? So, of course, the easy answer, you might be thinking, why is that a whole half of a chapter? I will have an easement if the landowner has given it to me in a deed, and then there is registration, then I have an easement. You're absolutely right. But that is expressly created easements. So, obviously that's there in the chapter also, but nobody's going to test you on that. Can you imagine the exam question? Paul gave Peter an easement via a deed and he registered it. Discuss. What's there to discuss? The answer is Peter has an easement. So nobody's going to test you on express easements. I take that back. Huh? Sometimes the examiner may throw it in as a side issue somewhere or whatever, but it will not be the main thing, and very rarely do I see it. So what the examiner will test you is he will give you a circumstance, he will give you a scenario, and Peter never got the easement expressly from Paul. Paul never gave the easement to Peter, but Peter still feels he should get it. So Peter will claim for the easement. So the second half of the chapter is, what are the circumstances and scenarios in which someone, even though the easement was not expressly given to them, they can argue that it was impliedly created in their favor. I repeat that. Huh? The second half of the chapter is where if someone did not get the easement expressly, what are the circumstances and what are the situations where they can argue that the easement was impliedly created in their favor? That's it. All right. Yeah, other than that, that's a general introduction to the chapter. If there are no preliminary questions, I don't expect to be any, but if there are no preliminary questions, let's start. Right? So this first paragraph here is essentially what I've just told you, right? Two things to discuss. So in an exam question also, your exam answer will be broken down into two halves. Right? So a typical exam question, which we will see tomorrow and the day after, right? And you already have it. In a typical exam question, there will be 3, maybe 4 rights. So in the beginning of the question, you call them rights. You can't call them easements. You don't know yet. 3, usually, sometimes 4 rights. Your job is to determine who is claiming for those rights. Next, are they possibly easements? Next, the person that's claiming for it, do they get it? So the answer is divided into 2, just like that. So let's start with the first bit. The essential characteristics of an easement. Okay, let's talk about this case, Ellenborough Park. This is the seminal case for easements. It's not a very controversial or honestly, it's not even an interesting case. But as you know how cases work, the judge that takes the time to write out the law properly, almost like a textbook, that case will become the important case. Right? So here, Master of the Rolls Evershed wrote down the requirements of an easement or the essentials of an easement clearly. Now, obviously, the judge didn't invent this, right? This is already something that was there in various case law. What the judge did was, as usual, he kind of took all the case law, he summarized it very nicely into these 4 points. So number 1, there must be a dominant and a servient tenement. Okay, now a few things that we need to make clear. Okay, tenement. What is tenement? Tenement means land. Please make that clear somewhere in your answer, absolutely clear. You know why? Because I have seen far too many answers where the people say the dominant tenement is Peter and the servient tenement is Paul. Right? It's a common mistake. Don't make the mistake. The word tenement means land. So when you're describing the servient tenement, which I haven't explained, so don't worry, right? When you're describing the servient tenement and the dominant tenement, you must be describing the land. So let's say, for example, right? 2 pieces of land owned by Mr. A and owned by Mr. B, and this land is called Black Acre and this land is called Blue Acre, let's say, for example. The tenements are Black Acre and Blue Acre, not A and B. Right? Now, again, at this point, you are probably thinking, of course, I know that. Why is he explaining it so much? But, you know, as usual, 1 month from now, 2 months from now, when your memory of the lecture is down a little bit, things can get confused. This is such a common mistake. And it is such a silly mistake to make, but it leaves an impression. If right in the beginning of the answer you said, the dominant tenement is Peter and A and the servient tenement is B, the examiner immediately has the impression that you don't know what a tenement is. And then that impression remains for the rest of the answer. You understand what I mean, right? So don't do that. Okay, firstly, so what is a dominant land and a servient land? So for example, in my A and B example, right? So let's say A stays here. This is his house. And A walks over B's land to get to the shops. Right? Why? Because it's a shortcut. Now, B has allowed A to do that. Ladies and gentlemen, now just purely from logic, and I think you can figure this out. Forget about law, for example. Purely from logic. Which land do you think is the dominant land? And which land do you think is the servient land? Because if you can figure that out, then there's nothing to memorize anymore. It's really that simple. Which land do you think is the dominant land? A's land is the dominant land. Why? It is the land that is benefiting from the easement. B's land is the servient land. Servient, root word servant, service, right? The servient land is the land that is burdened. The servient land is the land on which the right is exercised. You understand what I mean? Right? The servient land is the land on which the right is exercised. Again, the dominant land is the land that benefits. The servient land is the land on which the right is exercised. So, ladies and gentlemen, I think if you remember the second bit, that will help. So when you look at a problem question, when you look at a particular issue, a question or whatever, right? And you see there will always be two pieces of land, right? And then the right will be exercised on one land. That land is the servient land. The other land is the dominant land. That's the easy way that I figure it out in my mind. Whichever right. So it doesn't have to be a right of way, right? It can be a right to park. Maybe A is parking his car in the garage. This is the garage. Maybe A is parking his car in the garage. The dominant land is B's land. Notice, B's land, right? And then the servient land, sorry, I say that again. The dominant land is A's land, and the servient land is B's land. And then because, A is also a good neighbor, A tells B, why don't you come and you can swim in my swimming pool? In this situation, for this particular right, so B is coming into the swimming pool, right? For the swimming pool, then the dominant land will be B's land, and the servient land will be A's land. So once again, this is just a note that in a particular scenario, the dominant land is not a permanent fixture. That means this land is the dominant land always, and the next land is the servient land always. It, of course, depends on the easement, or depends on the easement that you are talking about, right? So in this scenario here, right, for the right of way, the shortcut to walk to the shops, and for the right to park in the garage, the dominant land is A's land and the servient land is B's land. But for the right to use the swimming pool, the dominant land is B's land and the servient land is A's land. Are we good? Now, of course, this is one of the most simpler parts of your answer. In an actual answer, you won't spend more than 2 sentences on this. The first sentence is to identify. The second sentence is to explain. That's it, very quickly. So you will say, on the facts, there is a dominant land, which is A's land, and then there is a servient land, which is B's land. The reason why B's land is the servient land is because the right is exercised on B's land. Done. No, you don't discuss anything more than that. It seems simple enough, but it is absolutely vital. If there is no dominant land or servient land, and servient land, an easement cannot exist. I repeat, if there is no servient land and dominant land, an easement cannot exist. So, for example, ladies and gentlemen, Mr. A owns this land. Mr. A tells Mr. B, Mr. B is just a random traveler. If you want, you can walk across my land anytime you want. B says, thank you very much. Is this an easement? This cannot be an easement. It cannot be an easement. Why? Because there is a servient land, but there is no dominant land. An easement is something that benefits the land, not the landowner. In fact, we are going to see that later. One of the requirements is that the right must benefit the land, not the landowner. Right? If the landowner benefits as a happy side effect, then that's okay. But primarily it must benefit the land, not the landowner. Okay? Now, why is this emphasized again? An easement cannot exist in ghosts. Obviously, because that's a requirement. But if you studied, or if you remember your freehold covenants is different. Huh? A freehold covenant can exist without the covenantor and the covenantee needing to have land. If you remember that, remember the case of Smith and Snipes Hall versus River Douglas Catchment Board, right? You are the landowner. I covenant with you. I don't have land. I covenant with you that I will take care of your fence. And then I don't. That's a covenant. You can sue me. Your subsequent occupier can sue me. But that's covenants. Huh? Easements cannot. There must be a dominant land. There must be a servient land. We okay? Okay. Let's move on. Second requirement. There must be diversity of ownership or occupation between the dominant tenement and the servient tenement. Okay, so diversity of ownership or occupation. Let's talk about that. So Mr. A, Mr. B, I'll be doing this a lot throughout this entire chapter, right? Now, Mr. A and Mr. B, let's say, for example, again, same example. So A lives here. This is his house, but he doesn't have a garage. B has a garage. So A is invited to park his car in B's garage. Okay? Now, simple example. So the dominant land here is A's land. The servient land here is B's land. Now, it is also a requirement that there must be diversity of ownership. Now, the example that I've given you here, there is diversity of ownership. What is that diversity of ownership? What does that mean? That means diversity, right? There must be different people who own the servient land and a different person that owns the dominant land. There must be diversity of ownership or occupation. Now, what is diversity of occupation? Diversity of occupation is a little bit different. A owns both pieces of land. Okay, let's stop here for a while. A owns both pieces of land. Can this be an easement? The answer is no. Why? There is no diversity of ownership. A owns the servient land. A owns the dominant land. No diversity of ownership. And there's no diversity of occupation also. A is staying in the dominant land and A is staying in the servient land also. But ladies and gentlemen, once again, you didn't need me to tell you this. Just think about it for a while. Sometimes when we look into the laws in so great detail, we forget about the big picture. And the big picture sometimes is just logic. If A owns the dominant land and A owns the servient land, then it's not an easement. It's just A walking on his own land. Isn't it? Right? So don't forget. Sometimes we need to, the details are important. Of course they are. But sometimes we need to just step back for a while and take a look at it, with a little bit of common sense, and you'll realize, oh yeah, I didn't need Daniel to tell me that. If it's my land, I am walking on my own land. It's not an easement. I can do whatever I want. You see? So for it to be an easement, there must be diversity of ownership. That's the example I gave you earlier. A owns the servient land, or A owns the dominant land, and B owns the servient land. Or diversity of occupation. How does that work? So A owns the servient land, but he leases it out to B. This is an example of diversity of occupation. Here, there's no diversity of ownership. Why? Who owns both pieces of land? A. There's no diversity of ownership. But ladies and gentlemen, remember, the requirement is diversity of ownership or occupation. Either will do. You don't need both. Either will do. So if you have diversity of ownership, very good. If you don't have diversity of ownership, diversity of occupation is enough. Are we good? Is it absolutely clear to everyone what is diversity of ownership and what is diversity of occupation? Now, the effect is the same. You just need either, right? But you must be able to explain to the examiner in your situation what type of diversity it is. Okay? Yeah, so let's look at some of these points here. Row against cedents, right? An easement is a right over someone else's land. This is what I told you earlier, right? So the dominant tenement and the servient tenement cannot be owned and occupied by the same person. If the land is owned by the same person but occupied by someone else, no problems. That's exactly what I told you. If the occupier of the dominant tenement is a licensee, then there cannot be an easement in his favor, as he owns no estate to which the easement can attach itself to. So if A here, in my original story, A here is only on the land by virtue of a license, not ownership of a lease, merely a license, then it cannot be an easement. Right? A needs to own the land, or at the very least, lease the land. At the very least, lease the land. Now, the lease doesn't have to be a lease that amounts to an estate. Don't worry about that. Right? Remember, more than 7 years and all of that. It doesn't have to be that, but it must at least be an estate. I mean, it must at least be ownership or a lease. Are we good? Okay, ladies and gentlemen, those two are the two quick and easy ones, right? In an exam question, those two will be done in 2 paragraphs, and you will move on very quickly. It's very important, so don't think that, oh, I'm downplaying, it's important, so you don't put it in the answer. No, it needs to be there, but it needs to be really quick and done, because there's not much to talk about. Okay, now, let's move on to the third requirement. Look at the language still, right? The alleged easement. Because still, ladies and gentlemen, at this point, you don't know whether it's an easement, isn't it, right? Right now, it's an alleged easement, right? The alleged easement must accommodate the dominant tenement. I was talking to you about this earlier. Notice what it says. It must accommodate. So accommodate means benefit, right? It must benefit the dominant tenement. What does tenement mean? Land. Not the law does not say it must benefit the dominant tenement owner. So this is becoming, this will be a major bit of your discussion. The law here has become, I mean, let me rephrase that. The law here was very confused for a while, because logically, what does it mean, benefit the land? Because the law seems to be very clear. It must benefit the land, not benefit the owner of the land. But what is land? Land is stone, sand, grass, right? That is land. How can, I mean, what is the logic of it must benefit the land, it cannot benefit the owner? What if the owner also benefits? And I think inevitably the owner will benefit, isn't it? In a lot of these scenarios. Look at all the scenarios I told you earlier. The right to park the car in the neighbor's garage. The land doesn't own the car. Who owns the car? The owner of the land owns the car, isn't it? But you see, that's not the way the law looks at it. Huh? So just let me just give you a very quick example, then we will start on this third point. Let's look at the parking example. So some of you may be saying, what the hell, Daniel? How does land benefit? How does the dominant tenement benefit when it is parking of a car? Well, the answer to that is this. The dominant tenement benefits because now whoever comes onto the dominant land will also get an extra parking spot, isn't it? Because an easement can be passed on. So the land, the dominant land, is now added in value. The dominant land is now more sought after. And that, ladies and gentlemen, means it benefits the dominant tenement. So this is going to be a bit irritating. Huh? The benefit here is going to be a very intangible kind of a benefit. It's going to be a benefit that you may not immediately see. But that example that I just gave you is a very quick idea of what we're going to be learning about. The land must benefit. Now, if the landowner benefits alongside the land, that's okay. The problem is what the law doesn't want and what the law will not allow is when the land does not benefit, but only the owner of the land benefits. Now, that distinction is not a clear and easy distinction to make. And that's why you know for sure that's what's going to be tested in the exam, isn't it? Right? So let's take a look. Let's take a look. Right? Yeah, so the following are some guidelines as to what is required, but they are not fixed rules, right? The first one. This is fairly simple. The two pieces of land must be sufficiently proximate to each other. What is proximate? Just the normal English meaning of the word proximate means close. For the land to benefit from the easement, the dominant land, which is supposed to be benefiting, right? The dominant land must be fairly close to the servient land. Then only it makes sense. Now, they don't have to be side by side. They don't have to share a border. But the further away the dominant land is from the servient land, the less likely it's going to be an easement. I repeat, the further away, I mean, it's also there in the notes, the further away the dominant land is from the servient land, the less likely it is going to be an easement. So what's the question that is playing on everybody's mind now? What is the distance? What is the minimum distance? You know how English law works, isn't it? Don't have. It's a case-by-case discussion. But the point is, and I'm sure you can see the logic as well, isn't it? The easement is supposed to benefit the dominant land. If the dominant land is, 50 kilometers away, how can we argue that the land benefits? Chances are it is only the landowner that is benefiting. Right? So the first point to note is both the dominant land and the servient land must be relatively close to each other. This has rarely been tested, but I think there was one question, I think about 20 years ago, I remember this. They said the dominant land and the servient land were in two ends of the village. So when you see things like that, the examiner is inviting the discussion. I've said this many times before, I'm going to repeat it again. The end answer is the least important part of the answer. The examiner just wants to see the discussion. He wants to see that you know it's an issue. He wants to see that you're addressing the issue. You know that the fact that it's on opposite ends of the village might be an issue, but you don't know how big the village is. You don't know how big the lands are. You don't know the nature of the easement. It could be, it could not be. Maybe it's not. That's what he wants to see. Right? So again, guys, I want to remind you, if you've forgotten, when you do property law, don't rush to get to the conclusion. That conclusion point, whether it's an easement or not, whether there is co-ownership or not, whether there is proprietary estoppel or not, that's the least important part of your answer. The important part of your answer is the getting there, the discussion, the cases. So sometimes we forget that and we cut through all the important part. In the mind of the examiner, that's the important part. But sometimes when we are pragmatic people, isn't it? Let's get to the answer, the solution. If I was a client of a lawyer, I want the solution. But see, this is not real life. This is an academic exercise. This is an academic paper. You must understand that. So they want to see the academic portion of it. That discussion, the debate, it could be this, it could be that, I don't know. Don't be afraid to say, I don't know. Well, if it's, I mean, if genuinely they didn't give you the information, then say, I don't know. The question didn't give me the information. Right? So don't forget, I think that's a major mistake that a lot of students make. Yeah, when they come out of the exam question, they talk to their friends, and the question that is asked is, so you said got easement or not? Did you say there was an easement? That shouldn't be what you're discussing at all. You may have said there's an easement. He may have said, no, it's fine. Okay? Okay, so coming back to this. There must be sufficient proximity. There must be closeness. Now, like I said, 99% of all your exam questions, the land is side by side. Right? So don't worry too much about that point, but it's there. Right? Secondly, this is the big one. The right must not be conferring purely a personal benefit on the owner of the dominant tenement. Let's look at some of these cases, right? Let's look at some of these cases. First case we look at is Hill against Tupper. Now, what happened in Hill against Tupper is, see, there was this hotel, right? So imagine this to be a multi-level hotel, right? And then next to the hotel, there was a river. The owner of the hotel did not own the land on which the river was flowing. Okay? The owner of the hotel owned the land on which the hotel was on. That's it. The river he didn't own. Now, what the owner of the hotel was looking for was an easement to park his boats here. Now, I mean, in nautical terms, when it comes to boats, you don't use the word park, apparently. You use the word moor. So he is looking for an easement to moor his boats, M-O-O-R, right? He's looking for an easement to moor his boats. Now, that's not a tremendously important fact, right? But I just wanted to tell you, right? He's looking for an easement to moor his boats. Why? Because he is running a cruise up and down the river. He is running a cruise up and down the river. He calls it a pleasure cruise up and down the river. Now, this cruise is open for anyone, not just the people who stay in his hotel. Anyone can come and use go on the cruise. Okay? What did the court say? The court said, no, it's not an easement. The court said it's not an easement. Why? Because the benefit here was purely a monetary benefit. The benefit here was purely a monetary benefit. It did not benefit the land. It only benefited the hotel owner. So, ladies and gentlemen, the law for a long time, and I say a long time because there has been some reform later, we will see, right? But for a long time, ladies and gentlemen, if the benefit of the easement was purely money, So like, for example, in this particular case, right, the owner of the hotel is running the cruise, right? How does that benefit the hotel? Some people argue, oh, there's extra attraction to come to the hotel, but you don't need to stay in the hotel to take the cruise. The cruise is not exclusive to the hotel owner, to the hotel's guests, right? The cruise is not exclusive to the hotel's guests. So the only benefit is that the hotel owner makes money. When it comes to an economic benefit, when it comes to a monetary benefit, the law has always been, no, it cannot be an easement. Why? Because money doesn't benefit land. Money benefits the landowner only. And if it only benefits the landowner, it cannot be an easement. Are we good? Now look, we're going to look through a few cases, and you're going to find that some of these cases are very, very similar, but then different outcomes. But let's just explore them first, right? So that's Hill and Tupper. Let's look at Moody and Steggles then. Now, Moody and Steggles is like this. So there was this row of shops. I mean, there probably were more in the row, but I'm just going to do 3, right? This shop was a pub. Now, the pub was looking for an easement. The owner of the pub was looking for an easement to hang an advertising signage at the end of the row. Right? To hang an advertising signage at the end of the row, advertising the pub. Does everybody understand the facts? The easement that was sought is an easement of advertisement or advertisement signage. That's also a recognized easement. To hang advertising signages is an easement. So the owner of the pub was looking for an easement to hang the advertisement signage. Now, based on the facts of Hill and Tupper, I'm not going to ask you, but based on the facts of Hill and Tupper, I think you would probably now say that, oh, this easement also is not allowed. Because why? Because advertisement signage means people look at the advertisement, they'll feel thirsty, then they'll go and buy some beer. Money. But here, ladies and gentlemen, interestingly enough, easement was allowed. The argument here was the entire, the land, the 100%, the nature of the land was the pub. The entire land was the pub. So if it benefits the pub, it also benefits the land, because the land is the pub. There's nothing else to that land, right? Now, if some of you are thinking, wait, this seems to be very confusing, because a lot of you will also argue, if a lot of people look at the advertisement, they go and buy beer at the pub, it is the pub owner that's going to be making money, isn't it? Monetary benefit. But here in this particular case, ladies and gentlemen, the courts argued, no, this one benefits the land also. Now, for a long time, guys, it was very difficult to reconcile some of these cases. The law is clear. I mean, the principle of what needs to be established is very clear. The easement or the alleged easement, the right, must benefit the dominant tenement. That part is not in doubt. The right must benefit the dominant tenement. But it did seem like what that means seems to be varying to different judges in different circumstances. And you will notice that these two cases are relatively close together in time. I mean, they are both very old cases, but they are about the same time, roughly. Right? And they were decided differently. So there were plenty of cases, ladies and gentlemen, that went on like that, where It was not easy to reconcile. Further, ladies and gentlemen, you'll have this added layer of complexity that some people argue. This was not stated in the judgment, but some people argue the Hill and Tupper case, the reason why it was not allowed was also for some policy reasons. The judge was reluctant to give one man control over the river. Like, that was like a public river. How can we give one man like kind of almost exclusive control over the river? You see? So every judge in different cases, different circumstances, sometimes leads to kind of confusing conclusions. That's one problem. Second problem. In the modern world, in today's world, in the 21st century, if the rule is, if there is a monetary benefit, it cannot be an easement, that might eventually kill off the law on easements entirely, isn't it? Because I think you can argue a monetary benefit from a lot of things. So if the rule was, if there is a monetary benefit from that easement, that means that easement, right? The right to park, the right to walk, right? If it's a monetary benefit, it cannot be an easement. Why? Because a monetary benefit, money can only benefit the dominant tenement owner, not the land itself. That's going to eventually seriously restrict easements. And see, the purpose of easements, ladies and gentlemen, is to maximize the usage of land. That's the whole purpose of easements, is to maximize the usage of land. Without easements, there will be a lot of pieces of land that cannot be used to its full economic, social, whatever optimal level without the easement. Right? There are landlocked lands. Have you heard of the phrase landlocked? Landlocked land is where there's a piece of land and surrounding the land is other land, obviously, that is owned by other people. The owner of that land in the middle, how is he ever going to leave his land? He needs to walk on someone else's land, isn't it? Whether it's the government's land or whether it's their neighbor's land, he needs to. If there was no concept of an easement, he cannot leave his land. That would be ridiculous, isn't it? More likely is nobody will own that land, and that middle land will be wasted. See, that's the purpose of easements. If you look into it, if you choose to do some reading, I mean, you don't have to, but if you get into the history of easements and all, it really blew up in the middle of the 19th century, because that's when land ownership in the UK changed. The UK had this feudal system, right? There'll be one lord for the particular huge piece of area. Right? How many of you watched this Downton Abbey? No, nobody. You like Downton Abbey? I like Downton Abbey very much. It's a very, it's an interesting TV show, right? It shows this whole English class warfare thing, and how the upper class was struggling to adapt to the modern world where class warfare is no longer relevant. Anyway, it's a nice show. Go and watch. But the point I'm making is, if you understand that, that's how the English were in the 19th century, early 20th century, right? There'll be one lord. He will either be an earl or he'll be a duke or whatever, and he will own a huge piece of land. The whole piece of land is his. Why? The king gave it to him. When the king gives you a title, they give you land. He gives you land. Then you have people working on your land. The people working don't own the land. They are working on the land. That's where you get working class and upper class, aristocratic class, right? You work on the land. And then you get a salary or you get something, but you don't own the land. But slowly, ladies and gentlemen, that changed. Then people started owning their small plots of land. Their little small plots of land, right? And then when you own a small plot of land, what's the problem? Last time, that huge piece of land had one source of water. That was enough. But now you own your small plot of land, and she owns her small plot of land, and he owns his small plot of land. Where are you going to get the source of water from? It's still that same one source of water. It has to go through other people's land to get to you, or you have to walk across another person's land to get to the water. You have to walk across other people's land to get to whatever other things. This is where the law of easements developed. So the whole idea of an easement, ladies and gentlemen, is that it must benefit the land, right? It must benefit the land, because the whole idea is to maximize the economic potential of the land, to maximize the social potential of the land. That's what an easement is for. Okay, fast forward 150 years. If the law will not recognize an easement purely because it confers a monetary benefit, then, ladies and gentlemen, a lot of easements won't work. And in the modern world, a lot of times it's about money. It's not just about I need to walk across the land to get my water to my farm and all that. It's not just about that. Sometimes it is economic benefits. So, ladies and gentlemen, with that in mind, the case of London and Blenheim Estates, can you see this here? 1992, this case kind of resolved this issue in an interesting way. First, let's talk about the facts of London and Blenheim Estates. So there was this huge piece of land, firstly, right? And this piece of land was a mall, let's call it, like a shopping area, right? A shopping area. And this was a car park. Okay? So the visitors of this shopping mall will park their cars here. Then obviously they will walk across here to get to the mall. And after they are shopping, they will walk across this land to get to the car park. The problem is, this land was not owned by the same person. This land was owned by someone else. Make sense? Right? This land was owned by someone else. So the owner of the mall, the Ladbroke Retail Park, right? The owner of the mall wants an easement for its customers or their customers to walk across this middle land while pushing their shopping trolleys. See, easements must be specific. We will see that later. They want an easement for their customers to walk across the land while pushing their shopping trolleys to their cars and back. Now, this is the problem. Looking at this, it does seem like this easement is purely an economic benefit for the owner of the shopping complex, isn't it? The retail park, the mall. Right? Why? Because if it is convenient to park your car, then more people will come and shop in your mall. And so it seems like it is purely an economic benefit. Right? So this shouldn't have been allowed if you were to follow the case of Hill against Tupper. Then you see Moody and Steggles was a little bit different. Remember the pub? Right? The whole nature of the land was the pub, so it was okay. But here, the judge once and for all decided to sort of settle this. Right? So look at this. So when it comes to the issue of commercial benefit, the case of London and Blenheim Estates, this is in the case of London and Blenheim Estates. When it comes to the issue of a commercial benefit, today, the issue is not whether a commercial use is being facilitated by the easement. Okay, so this is resolved today already. The issue is no longer whether the easement gives you a monetary benefit, whether the easement gives you a commercial benefit. That means you cannot discount the easement immediately just because from the easement you are potentially, you can earn money. No more. Right? So I read that again. The issue today is not whether a commercial use is being facilitated by the easement, but whether the alleged easement is so connected with the land that the benefit accrues to the current owner because he owns an estate in the land. That should be in the land. Huh? Let's read that again. Look, I know it's not absolutely clear from the first reading. It is tricky. Let's do this again. We do this slowly. Firstly, again, let's make it absolutely clear. Today, if as a result of that easement, the benefit of the easement is money or some kind of economic benefit, commercial benefit, it's okay. It doesn't automatically negate the easement. Are we good there? There was a point where that was the case. Right? Many cases in the middle of the 20th century, if the easement was the whole purpose of the easement was purely generating money, the courts will immediately say, no, it doesn't benefit the land. It only benefits the landowner, cannot. So today, that doesn't matter. Okay, but it's not a free for all. So even if there's an economic benefit, it's okay. But the issue is whether the alleged easement is so connected with the land that the benefit accrues because the owner owns the estate in the land. That means what they're trying to say is, it's okay that the dominant tenement owner is getting money from the easement. It's okay. But is he getting that money because he is on the land? That means, is he getting that money because he owns the estate in the land? Now, an easier way to understand this, and this you won't find in the textbooks. This is me telling you this. Let's try and understand this first, then we come back to the words. Think about this. If you remove the dominant tenement owner from the land, just imagine this. Just imagine. You remove the dominant tenement owner from the land. That means he doesn't own the fee simple of the land. He doesn't own a lease in the land. Will he still be making money from the easement or not? That's the question to be asked. If he was not the owner of the dominant land, if he was not the lease owner of the dominant land, will he still be making money? If the answer is yes, that means whether he is on the land or not, he is going to be making money from the easement. That cannot be an easement. Why? Because the benefit, the monetary benefit, is not accruing to him because he owns the interest in the land. But if you remove him from the land, again, imaginary, if you remove him from the land, he doesn't own the fee simple of the land. And because you have removed him from the land, that easement doesn't make sense for him anymore. He cannot make money anymore. That means the only reason he was making that money is because he was on the land. That can be an easement. Okay, right? This is the same faces I see every year. Don't worry, you are not alone in this. It is tricky. It is tricky. But let's apply this to the three examples that I've just given you. The three cases. So let's work backwards. Let's go back to Hill against Tupper. In Hill against Tupper, if the guy was not, the dominant tenement owner did not own the hotel. Remember which is Hill and Tupper? This one, right? If the dominant tenement owner did not own the hotel, will he still be making money from the cruise? I mean, he owns the cruise still, right? Remember, the easement that he wanted was to park his boats on the river, right? Will he still be making money from the cruise or not? I argue yes. Remember, anyone can come onto the cruise, right? It's not exclusive to the hotel owner. So imagine this. If he did not own the hotel, will that easement to park his cruise boats, on the river, will he still be making money from it? The answer is yes. If that is the case, according to London and Blenheim Estates, that cannot be an easement. Why? Because the monetary benefit is not because he owns the estate in the land. Look at Moody and Steggles. The pub. Imagine the guy, the dominant tenement owner, did not own the pub there. Right? Imagine the dominant tenement owner did not own the pub there. Does the advertisement make sense for him? No, isn't it? The advertisement says what? Come to this pub and drink beer. He doesn't own that pub anymore. Does the advertisement benefit him in any way? No. Yes, it does benefit him monetarily, but it only benefits him monetarily, and once again, because he owns the estate in the land. In this case, because he owns the estate in the pub. So according to London and Blenheim Estates, this will be okay. So again, let's read London and Blenheim again. It doesn't matter that the benefit is an economic benefit. But if the economic benefit is there, is accruing to the dominant tenement owner because he owns the estate in the land, that will be okay. So in a way, ladies and gentlemen, what the courts are doing here is they are recognizing that if we were to totally ignore economic benefit, it just makes no logical sense in the modern world. So what they're saying, if the benefit is a monetary benefit, it's okay. But it must be because you are the owner of this land. You are getting the money because you are the owner of this land. If the land is not relevant to your earning the money, it will not be an easement. If you are earning the money because you own the land, that's okay. Look at the third case, the London and Blenheim case itself. Who is the dominant tenement owner? The owner of the mall, correct? Who is the servient tenement owner? The owner of the, not the car park, but that middle land that they have to walk across, right? That's the servient tenement owner. The dominant tenement owner, the owner of the mall and the car park, they want a right for their customers to walk across the middle land. Okay. You may argue that's a monetary benefit. Fine. The law today, London and Blenheim says, is it a monetary benefit? Yes. But it's okay. The question to be asked is the dominant tenement owner getting that monetary benefit because he owns the dominant land? So how do we answer that question? Again, imagine it. Ask yourself. The dominant tenement owner, let's say he didn't own the mall and he did not own the car park. Let's say he did not own the mall and he did not own that car park. Does the right for people to walk across that middle land, is it relevant at all to him? Nothing, isn't it? It makes no sense to him. It makes no monetary value to him. It only is beneficial to him, albeit monetarily, but it is only beneficial to him because, again, you will notice that I italicized the word because. Because that's the important part. It must, that the money must be accruing to him because he owns the estate in the dominant land. Okay? So, ladies and gentlemen, this resolves the issue of commercial benefit. Now, in an exam question, is it always going to be commercial benefit? No, not necessarily. Right? So let me give you some examples of this very quickly. Right? Let me give you some examples of this. Now, it is not, again, it is not a science. I mean, I'm stating the obvious, but it is not something that can be deduced clear cut. It is something to argue, okay? But generally, right? If Mr. A and then Mr. B, and then Mr. B says, Mr. A, why don't you park your car in my garage? Chances are this is not an economic benefit issue. It's just telling Mr. A, if you want, you park your car in my garage. Don't overthink it. Oh, it is economic benefit because now A doesn't have to pay to find parking for his car somewhere else. It's not, right? Now, a little bit different. A runs a mechanic shop, a garage, right? Fixing cars. His business is fixing cars. Many cars come and park on A's land. Sometimes A doesn't have enough land. Then B, being a good neighbor, says, ask your customers to park your car here in my land. This, ladies and gentlemen, will be an economic benefit issue. So when you see the issue is an economic benefit, then you argue London and Blenheim estates. Like for the earlier example, you need not argue commercial benefit. You can argue it benefits the land directly. How does it benefit the land? This is what I told you earlier, right? When if this is an easement, right? If this is an easement, it benefits A's land. The reason is because from now onwards, whenever A sells the land to whoever C and C sells the land to D, this land will always have that extra car park there. It adds value to the land. It benefits the land. It makes the land more attractive. It benefits the land. So this concept of benefiting the land, like I said, it is a bit intangible, but that's something that you need to discuss. Are we okay? Are we good with this benefiting the land concept? Okay. Summary. The easement must benefit the land, not the landowner only. Traditionally, if the benefit was a monetary benefit, it was always seen as benefiting the landowner only. Why? Money doesn't benefit land. But I mean, I think it's a good decision. So in light of the times and all of that, today that has changed. Today, according to the case of London and Blenheim Estates against Ladbroke Retail Park, if the benefit of the easement is purely a monetary benefit, it's fine. The issue is that monetary benefit, is it accruing to the dominant tenement owner because he owns the estate in the land? So for you, how do you test that? Just remove him from the land. If you remove him from the land, and when I say remove, I mean he doesn't own the land anymore. Remove him from the land. Does he still make money from that easement? If the answer is yes, it cannot be an easement. If the answer is no, then it can be an easement. Okay? Okay. Now, also, ladies and gentlemen, what I should say, a lot of these things will become clearer when we do questions. Right? A lot of land law, right? When you start looking at the actual questions and you see how the law is actually applied, it'll become clearer, right? So I think we are okay here, but just in case we are not, obviously, please ask if we are not. But I also will tell you that when we look at the questions, you will see how this works. Okay? Okay, next point. Now, firstly, I must explain, we are still point number 3. The third requirement or the third essential under Re-Ellenborough Park. Now, when I say the third essential, and then after that, we have been looking at, the proximity, it must not confer purely personal right. It's not that all these things must be satisfied. These are just potential issues. If it is relevant on the question, you discuss. If it's not an issue in the question, don't discuss. The third one is recreational use of land. Recreational use of land. Can an easement be an easement of recreation? Can you get an easement to play? Now, the answer to that question is can, but the easement must be clear. So you can have an easement of recreation. Now, traditionally, and when I say traditionally, I mean, 100, 150 years ago, easements of recreation were not seen as important. Right? Easement of recreation, that means, can I get an easement to play football in my neighbor's land? Can I get an easement to go jogging on my neighbor's land? Right? Now, all this was not seen as important because, again, the question is, how does it benefit the dominant land? It seems to only be benefiting the dominant land owner. However, ladies and gentlemen, the courts have recognized that an easement of recreation is accepted. In fact, the case of Ellenborough Park itself, that is the very case that we are looking at, remember? Where are we? Oh, I'm going the wrong way. Ellenborough Park. The case of Ellenborough Park itself was an easement of recreation. Right? As its name would suggest, the case is about Ellenborough Park. Ellenborough Park is one of these private parks, right? Again, in the UK, it's a bit strange. I say strange because, of course, in my country, it's not like that at all. But there are these private parks. I don't know whether it's the same in Hong Kong or not, where all the houses around that area will have a special key to that park. And that park will actually be a gated park, right? So that they don't allow the riffraff to come in. Again, this is an old-fashioned concept. So the issue here is, do the people around that space, they were looking for an easement to walk on the park as recreation, right? Not to get to the other side, not for any purpose, to walk while pushing baby strollers. That's an important part of the case as well, because that was the easement. To walk while pushing your pram, your baby strollers, right, in the park. So that was the easement that was sought in the case of Ellenborough Park. And there it was allowed. Right? There it was allowed. So, ladies and gentlemen, even as early as the 1950s itself, when Ellenborough Park was decided, an easement of recreation is allowed. But the courts have been very careful with allowing easement of recreation. And the courts have been very careful with allowing an easement of recreation. Now, let me tell you why. And I always want you to understand the logic behind it. As much as I told you easements are important to enhance the economic and social value of the land, that is one point of view, right? That's important, that is true. But the other side of the coin is someone else's land is now going to be burdened. Correct? If you are just looking at, it will enhance the economic benefit of my land to give me that easement, which is correct, but the other side of the coin is there's going to be someone else's land that is going to be burdened. I will be able to exercise that easement on that land. So the court needs to balance that out. The court cannot just be like, okay, fine, for the economic benefit of your land is burdened. Cannot. That's not fair. So the courts are careful. And you will see how careful they are in the second half of this lecture, right? You'll see how careful they are. And that's why the law is unnecessarily complicated, because the law is so careful. Right? So the courts have been careful with allowing an easement of recreation. It's always been a doubt whether an easement of pure recreation can or not. Now that has been resolved in the relatively recent case of Regency Villas versus Diamond Resorts. Now, in this case, if you read judgment, the court actually said, in today's modern world again, and these are all cases that seem to be showing you that the courts are willing to expand the law to suit the times. Right? So it says in the modern world that we live in today, the majority of people sit down for their work. Right? And human beings are not supposed to sit down the whole day. Right? Human beings are supposed to work, right? I mean, our bodies are built that way. And if you just sit down the whole day, then you end up, well, looking like me. So the court said the right to recreation is not just something that is nice to have, it is important. It is necessary. So the courts held that the law shouldn't be afraid to grant easements of recreation. So the value of Regency Villas against Diamond Resorts, ladies and gentlemen, is just that it stands for the proposition that the courts don't have to be worried, reluctant to grant easements of recreation. They can. However, it cannot be it cannot be just a vague right. It cannot be an ill-defined right. And this goes back to what I told you earlier and what we're going to see after this as well. An easement is a burden on someone else's land. It must be fair that that burden must be clearly defined. So if you are asking for an easement to play, your easement will fail. If you are asking for an easement to have fun on my neighbor's land, your easement will fail. But if you are asking for an easement to play tennis on the tennis court on your neighbor's land, that might be successful. Right? So don't overuse Regency Villas. Regency Villas just stands for the proposition that the courts need not fear, or the courts need not be reluctant to grant easements of recreation. That's all it says. The requirement that easements in general, not just easements of recreation, but easements in general must be clear, must be precise, still applies. Still applies. Right? So, easements of recreation, today after Regency Villas, it will be easier to establish. Right? In an exam question context, once in a while this comes out. Not very regularly, but it does come out once in a while. So a right to use your neighbor's swimming pool. That's an easement of recreation. The right to use your neighbor's tennis court. There was a few years ago, there was a right to box in the neighbor's boxing ring, that kind of a thing, right? All this is an easement to recreation. When you see an easement to recreation, then it's Ellenborough Park, Regency Villas. That's what that needs to come up. Okay? Lastly, okay, I'm just going to finish this, then we go for a break. Accommodate does not mean it must be needed. So what is accommodate again? Earlier we said accommodate means must benefit, right? Remember, so the third requirement in Ellenborough Park is it must benefit the dominant tenement. It must accommodate the dominant tenement, right? So again, same story. Mr. A, Mr. B, Mr. B has a garage. Mr. B has told Mr. A that he can park his car in the garage. Now, the facts now indicate that Mr. A has 2 more garages here that are empty. Now, don't ask the logic of why he wants to park in his neighbor. Just suspend that logic. Just follow my story, right? Mr. B told Mr. A, you can park your car in my garage. Mr. A has decided, okay, I will take you up on your offer. I will park my car in your garage. But Mr. A also has 2 empty garages in his own land. The question here is, does this benefit A? Not A. Does this benefit A's land? The answer is still yes, sir. It does benefit the land. That is why it stays here. Accommodate or benefit does not mean it must be needed. You cannot argue, oh, actually, this easement is not an easement because you don't really need it. You got 2 extra empty garages. You didn't need it. It doesn't work. It doesn't matter. Right? Benefit means, yes, now with this easement, A's land will always have this extra car park, which is a good thing. It benefits the land. Benefit doesn't mean need. You understand what I mean? Right? So the case of Polo Woods versus Shelton Agar, 2009, underlines the fact that accommodate or benefit does not mean it must have been needed by the dominant tenement. Okay, once again, guys, these are the, like I said, these are not 4 requirements that must be established. These are just issues that can come up for the 3rd requirement of Re-Ellenborough Park, right? The time now is 8:31. Let's take a break here, 10 minutes. We come back, we will continue with the 4th requirement, the 4th essential of an easement in Re-Ellenborough Park. Okay? And also, if you have any questions, gather them, write them down. When I come back, we can start off with questions, right? So probably you only have one more chapter left, lah, adverse possession. Okay. Which means in theory, you should be able to sit for the exam already, you know. In theory, lah. I've said before, there are 8 questions in the exam, 8 topics, 8 questions. So every chapter is going to be tested. In my opinion, you can safely drop 2 topics. And I say that not ironically, I will say safely, but provided that you are well prepared for the remaining 6. No? All right, well prepared for the remaining 6. You are able to do any type of, at least you are preparing to do any type of question that come from the remaining 6. You can kind of drop 2 chapters. The 2 chapters that you should be dropping from, I mean, they should be from the later chapters. If you are going to drop, of course, the best thing is to do everything, right? But if you wanted to drop, it should be, you shouldn't be dropping registration. I think that's not great, right? So, you know, adverse possession, easements, mortgages, freehold covenants, leases, those chapters is what, if you wanted to drop, you can drop there. Then co-ownership and proprietary estoppel kind of come together. Although they are 2 separate and distinct chapters, exam questions will come. There will be a PE question, there will be a co-ownership question, but sometimes they come linked. There is a possibility, if there are any 2 chapters that are at all linked, it is definitely PE and co-ownership. So those chapters, don't make the silly mistake of studying PE and not doing co-ownership, or doing co-ownership and not doing PE, right? So that needs to be done together. Although it's 2 questions there, but that needs to be done together. Registration, it just, I know it's tricky. It was your first chapter. That time you didn't know what was going on. So you don't know, maybe you don't quite understand what's going on with registration. But I think you need to put that effort into registration, because registration becomes useful for the entire syllabus. See, like after this, we are going to learn easements. Then when we finish easements, what are we going to learn? How to register easements. It will become a relevant part of the question. When we did freehold covenants, how to register freehold covenants. When you did leases, how to register leases. What is a legal lease? What is an equitable lease? So if you're already going to memorize that for all the other chapters, you might as well do registration, isn't it? So that's my very unscientific advice. Yeah, you should think about which chapters you want to do, but wait until you have studied adverse possession first, right? Wait until you've studied adverse possession first, then make the decision. Very good. Okay, now, quick recap. We are looking at the essentials of an easement. That means, what are the essential characteristics of an easement, right? That means when you look at a particular right, you cannot just assume it's an easement just because it is the usual type of easement, right? So it must satisfy the 4 requirements in the case of Ellenborough Park. We have gone through the first 3. There must be a servient tenement. There must be a dominant tenement, number 1. Number 2, there must be diversity of ownership or occupation between the dominant tenement and the servient tenement. Number 3, the right or the alleged easement that we are talking about, right? The right that we're talking about must accommodate the dominant tenement. Accommodate means benefit. And remember, dominant tenement is the land, not the dominant tenement owner. And now we are in the 4th requirement, the 4th requirement of Ellenborough Park. The alleged easement must be capable of forming the subject matter of the grant, which simply means that that right that you're talking about must be a right that is capable of being an easement, right? It must be a right that is capable of being an easement. right? So there are some basic questions that we must answer straight away, right? There must be a capable grantor. There must be a capable grantee. So grantor, grantee, right? You see this a lot in property law, right? Mortgagor, mortgagee. Covenantor, covenantee, right? Same concept. Huh? So the grantor is the person who is granting, who's doing the granting. The grantee is the person who is getting the easement. There must be a capable grantor. What is a capable grantor? You must actually own the land, right? Before you can give an easement. Just imagine if today I told you, don't worry, guys, you can come and park your car in the car park of Hong Kong Poly U. Don't worry about it. Just mention my name. Is that of any value to you? No, because I do not own this land. I am not a capable grantor, right? So for it to be an easement, there must be a capable grantor. The definition of a capable grantor is you must own the estate in the land, the freehold, or at the very least, the leasehold. Okay? Then capable grantee, same thing. The person who is receiving the benefit of the land also must own at least the freehold or at least a lease on the land. Correct? Remember, this is what I refer to the first Re-Ellenborough Park requirement. There must be a dominant tenement and there must be a servient tenement. So the capable grantee cannot be someone that is without land. He cannot be someone that does not own the freehold or at least a lease in the land. Okay? Now this is extremely easy. This will not take more than one sentence for both, in fact, in your answer. But, I mean, it is relevant. It needs to be discussed. Now then, this is important. The rights that are capable of forming the subject matter must be sufficiently certain. So we've seen this, isn't it? Throughout point number 3 and point number 2 also, we've seen this. The right must be sufficiently certain. We cannot have a situation where the easement that you are talking about is so vague and so uncertain, right? So when we were talking about the easement of recreation, remember I told you, you can't get an easement to play, full stop. But you can get an easement to play tennis in the tennis court in the northeastern part of the land. Let's say, for example, that's fine. So you see some examples here. You cannot have an easement of a good view, right? You cannot argue that you have an easement of a good view. That means this is your land, your neighbor's land is there. Suddenly your neighbor is building a tall building and blocking your view. You cannot go and argue that I have an easement of a good view. It's too vague, too ill-defined. However, ladies and gentlemen, again, if it was granted in a way, or if you are arguing that you have an easement of a view of the mountains from the eastern window on the second floor of my building, that possibly can, right? So, ladies and gentlemen, a good rule to remember is, can you describe the easement with certainty in writing? So that someone else who is not, who doesn't know what you are talking about, someone else who reads it knows exactly what you're talking about. That, ladies and gentlemen, is the level of certainty we need. Because remember, it's about a third-party purchaser who's buying your neighbor's land. When he reads the title, he should be able to identify exactly what your rights are on that land, isn't it? So that's the kind of certainty we're looking for, right? So a right to a good view cannot, no easement of privacy. So these are all just general examples. But in general, any easement that is too vague and ill-defined will not be enough. However, there is this interesting case of Coventry against Lawrence. If any of you are doing tort as a module this year, you may have come across this case. Does it sound familiar to you? Coventry against Lawrence. So to be fair, I also don't know tort, right? The last time I studied tort was more than 20 years ago, right? But students, whenever I teach, they'll tell me, this is a tort case. So that's where I'm saying, right? Now, in the case of Coventry against Lawrence, the court here said that this criteria maybe shouldn't be applied so rigidly. So once again, guys, there seems to be a development in the law that the judges today are willing to expand the definition of an easement, because the easements were always the most tightly guarded right, because it affects another person's land. It burdens another person's land. The courts were always very, very, very reluctant to easily grant easements. But it does seem that recently there seems to be a change in this attitude. For example, Regency Villas, the right to recreation. Another example is this case, Coventry against Lawrence. He said, Justice Lord Neuberger in the Supreme Court said that in his opinion, it is perfectly possible for an easement to create noise to exist. Ladies and gentlemen, before this case, if you came and asked me, can there be an easement to create noise? I would have told you rubbish. That's wrong, cannot. Because what do you mean by creating noise? It's too vague, it's too ill-defined, isn't it? But in this particular case, the judge in the Supreme Court actually held can. Well, to be fair, it's only obiter, right? It's not binding. It was just his opinion, right? But he did say that an easement to create noise may be possible. So is this a good thing or a bad thing? If there's ever an essay question on easements, this could be an essay issue. Is the development of the law is relaxing the rules on when an easement can exist? Is that a good thing or a bad thing? I think it's a good thing, right? As long as it helps the usage of the land and it doesn't unnecessarily burden other lands, I think it's fine, right? The law must always keep up with the times, isn't it? Right? Anyway, Coventry against Lawrence, remember that case, not for any real, it doesn't change the law on easements at all. Number one, because it's only obiter. But Coventry against Lawrence seems to suggest that there is this possibility that judges are willing to expand what they think are easements, willing to expand the scope of what could possibly be an easement. Right? One of the sample answers that we will do, or I have uploaded, is an essay question. We will look at that as well. Okay. Now, next. So firstly, there must be a capable grantor, capable grantee. The right that are capable of forming the subject matter must be sufficiently certain. Then, the right must be capable of being an easement. Now, the right must be capable of being easement simply means that there are certain things that will negate the existence of an easement. Negate means what? It means we'll cancel out the existence of an easement, right? There are certain things, if they are present, if they exist, that right cannot be an easement, right? So you must check out whether these issues that will negate an easement are there or not. Firstly, the courts will not recognize an easement that requires the servient tenement owner to spend money. Please note, this is only specific to servient tenement owner. So once again, who is the servient tenement owner? The guy that owns the land on which the right is being exercised, correct? Already his land is burdened. Now, to maintain that easement, he must spend money. It won't be an easement. The courts will not allow it. Right? The courts will not allow it. Now, there are exceptions to this, but they are very, very specific exceptions. So you see the case of this one, Cardwell against Walker, for example. Right? This is an exception to what I just told you earlier. Remember, the general rule is the servient tenement owner must never be required to spend money to maintain the easement. So, for example, this is why an easement to use a swimming pool will likely never to be an actual easement, because maintaining a swimming pool costs money, right? Right? How many of you have a swimming pool at home? Right? If you do, it's good. Huh? I don't. But I understand that maintaining a swimming pool is expensive, right? It's expensive. You got to clean it and stuff, right? So one day, if you decide, look, I don't want to maintain my swimming pool anymore because I don't want to pay that money. Now your neighbor is going to come and argue you are defeating his easement, isn't it? Because you are not maintaining the swimming pool. He is arguing that he has an easement to use your swimming pool. But the courts will say it cannot be an easement to begin with. Why? Because it involves expenditure of money by the servient tenement owner. It cannot be an easement. But an example of an exception is Cardwell against Walker. Justice Neuberger accepted that the servient tenement owner must provide electricity from a private supply of his to the dominant tenement owners, because the absence of this would make the dominant tenement unusable. So the issue here was the dominant tenement owners bought the land from this guy. So let's say you bought your land from me and I sold it to you because there were some bungalows there that tourists can use. And the purpose of you buying it from me is because you wanted to use it for tourists. Our entire transaction is that you are going to rent it out to tourists, like holiday bungalows. What do holiday bungalows need? Among others, electricity, isn't it? So now suddenly I cannot say like, oh, I don't want to give you electricity. The electricity comes from my supply. I said, no, I don't want to give you. Then you argue, no, I have an easement to use your electricity. You argue, no, but I have to spend money. So it cannot be an easement. Now, the general rule is I am correct. Huh? The servient tenement owner cannot be spending money. If the servient tenement owner has to spend money, then it cannot be an easement. However, Justice Neuberger said in this situation, it's a little bit different. The entire transaction was premised on the basis that you are buying the house for a holiday home and I will provide electricity. So it wasn't just an easement in that sense. Okay, but ladies and gentlemen, although we have a clear case here, Cardwell against Walker, please note or write it down somewhere, it is an exception. The general rule stands firm. The general rule is that you cannot, that the servient tenement owner cannot be expected to spend money. If the servient tenement owner is expected to spend money, then it cannot be an easement, or the courts will not recognize it to be an easement. Okay? Next. This is a big one. Put a star next to this. I almost guarantee you this one will be tested. Every single question has this issue. It's, if I were to put it simply, it is an issue of degree of use. Degree of use. Okay, let's go back to the first few words I told you when I started this lecture. What is an easement? An easement is a limited right on someone else's land, right? An easement is a limited right on someone else's land, which is fine. Now, if that right now becomes to a degree where the servient tenement owner cannot use his own land already, right? Like I am the servient tenement owner, you have an easement on my land. You have an easement on my land. Your use of the easement has gone to a degree that I no longer have reasonable use of my own land. It cannot be an easement. even if it satisfies all the other requirements, if the degree of use is to a point where I, the servient tenement owner, no longer have reasonable use of my own land, it cannot be an easement. So, very quick example, right? I let you store your boxes in my garage. So you come and put 2 boxes there. I've got so much more space in my garage. Perfectly fine. But you come and put 20 boxes there. And my garage is not very big, right? So now, because of your 20 boxes in my garage, I cannot park my car in my garage. The courts will not say that that's an easement. It doesn't exist as an easement. Even if you have a piece of paper, I have given you a deed and plus registration, all of that, right? This is going to the very existence of the easement. Don't think that just because there's a deed and there's registration, it must be an easement. Only if it is an easement to begin with, can I give it to you. So now it's going back to the very root. So if you argue, oh no, I have an easement to put however many boxes I want, but the point is you have put so many boxes that I no longer have reasonable use. Notice I'm always emphasizing reasonable use because that's the test. We will look at it later, right? If I no longer have reasonable use of my own garage or my own storeroom or my own land, that cannot be an easement. That cannot be an easement. Are we good? Now, you know how the examiner will test you this? He will test you in a very, very irritating way. He will not tell you how big your garage or storeroom or barn, he won't tell you how big it is. And he won't tell you how big the things that are going to be stored there, how big your car is, he won't tell you that. So it's a matter of you having to discuss it on the facts. Right? Every single question is like that. Almost every single question is that. They will say, John claims that he has an easement to park his, they won't say bicycle, but they will say, what's that? They always find very interesting vehicles. One year it was a combine harvester. That's another irritating thing. What is a combine harvester? In the stress of the exam, you're sitting there and you don't know what is a combine harvester. It's a bit of a problem, isn't it? Now, to be fair, I'm not a farmer. I didn't know what a combine harvester is. I Googled it. So, briefly put, it's a very big farming implement. Right? It's a very big farming implement. Because that matters. Because you're going to argue this is a very big vehicle. I don't know how big the garage is. If by parking the combine harvester in the garage, there is no more space, then it cannot be an easement. However, if the garage is big enough to park the combine harvester and still there is room for other things, then it will be okay. That's the kind of answer you need to be giving. Right? Anyway, let's look at some cases, right? So these are some comparison cases. Copeland against Greenhalgh. Copeland against Greenhalgh, the courts held that there was no easement to store tools on the servient tenement. Why? Because the usage was too excessive, right? No easement, right? Same thing with Grigsby against Melville. The usage was too much. But in comparison, Wright against McAdam, it was allowed. And it was all the same thing, storage in someone else's land. Why? Some easements are okay, some easements are not. It comes down to degree of use. How much are you using of your neighbor's land, of the servient tenement's land, right? Batchelor against Marlowe. This is the parking cases. In Batchelor against Marlowe, it was 2 cars. 2 cars were parked on the servient land. The courts held that the impact on the land was too much. But in the Nissan Motors case, as you can see on the notes, in the Nissan Motors case, it was 80 cars. 80 cars. But there it was held to be enough. Why? Because the neighboring land was huge. even after parking 80 cars, there was more than enough space for the servient tenement owner to use the land. So again, ladies and gentlemen, the lesson here is this is not a quantifiable thing, or if it is more than 2 cars, cannot. It's about case by case, look at the impact it has on that particular land. So the examiner will tell you, he'll give you small hints, but it'll never be enough for you to make a firm conclusion. You'll say, the neighbor, you are running a mechanic shop, the neighbor says you can park your customers' vehicles in my land. But he also says, my land is not very big. What do you mean by not very big? Again, there will be no firm answers. You will have to discuss it, right? So that's what I mean. It's an issue to be discussed looking at all the facts of the case. So this is something case by case. Okay, then before we leave this particular issue, the last case we want to talk about is Moncrieff against Jamieson. Moncrieff against Jamieson. Now, firstly, you must note that this is a Scottish case. A Scottish case immediately is not directly binding. It's only persuasive. Okay. Secondly, even if it was directly binding, it was only obiter. In Moncrieff, it was only obiter. And thirdly, this has never been followed in all future cases. Right? What did Moncrieff say? The judge's name here was Lord Scott. Lord Scott in Moncrieff, he tried to redefine the test. The test as it stands now is reasonable use, which is a relatively high standard. That means the servient tenement owner must always have reasonable use of his own land. Lord Scott in Moncrieff tried to lower the standard to reasonable control. What is the difference between reasonable use, reasonable control? For example, if this room is my land, reasonable use means if my neighbor is using my land, I also can use my land. That's reasonable use. Reasonable control is as long as I have the key to the door, that's reasonable control, no? My neighbor may be using every inch of my land. I no longer have use of my land, but because I have the key to the door, I have reasonable control enough. Can you see how reasonable control is a much lower standard, which means it's much easier to establish the easement? So, Lord Scott, in the case of Moncrieff, tried to argue that the test should be reasonable control, not reasonable use. But ladies and gentlemen, generally this view has not taken off. Nobody has adopted it. In fact, it has been criticized. So then why am I giving it to you? This is the small ways for you to bluff the examiner that you read a lot of cases, right? So if you find yourself, your exam question, you find yourself in a situation where the person that you are advising is going to lose the case. He is not going to get the easement. Why? Because his use of the easement has gone beyond the allowed degree. His use. So your client is the dominant tenement owner, right? His use of the easement on the servient tenement has gone beyond the acceptable degree of use. It should fail according to the reasonable use test. That's when you say, yeah, it is likely to fail. However, there is this case called Moncrieff against Jamieson. Now, although it's not been accepted, you humbly argue that this court should accept it. Do something like that. No? See, that's the kind of thing that the examiners like. You understand? They don't care, at the end whether the easement is going to be successful or not. They want to see that you know many cases. So add on to these cases here. Go read the textbook. Pick on more cases. Right? So the interesting arguments that you put forth on the facts of each case is what is going to give you your A or your second upper mark, a B+. You understand what I mean? Okay, ladies and gentlemen, those are the 4 requirements of Re-Ellenborough Park. Right? Anytime you want to establish an easement, you need to sit down and see whether these 4 requirements are established or not. Also, ladies and gentlemen, you must note that the courts also take into account public policy. I hinted at this earlier. We will get into it a little bit detail now. Right? Just look at the notes. Now, although this public policy thing is not expressly stated anywhere, right? You don't have to say, oh, public policy is requirements to establishing an easement. It's not really. But generally, the courts must always take into account public policy. What is public policy? Public policy is, I mean, in any kind of application of the law, the court must be in a position where they think, I cannot just blindly apply the law because it's the law. You must see the impact of the law on society. We must see the impact of the law on the community. These are public policy considerations. So we have seen that the courts do take into account some public policy considerations, right? You see, the Re-Ellenborough rules are sufficiently loose to allow some external considerations as well, right? It only tells when a right is capable of being an easement and not when it must be an easement. So this is the other thing that probably irritates everyone. Everyone just wants, just tell me lah. These are the 4 requirements. 1, 2, 3, 4. I will study hard and I will apply it. But you know, law doesn't work that way. So these 4 requirements are kind of very loose rules, but the judges still retain a lot of discretion on a case-by-case basis. See, you take a look at Coventry against Lawrence, where Justice Neuberger said, an easement to make noise may be an easement. Yes, it's an obiter statement. It's not ratio decidendi. It's only obiter, but that gives you that gives you an idea of the kind of discretion judges have to apply on a case-by-case basis, right? So once again, it only tells, Re-Ellenborough only tells us when the right is capable of being an easement and not when it must be an easement. For example, I suspect all of you just now, when I explained Hill against Tupper, which is the pleasure cruise case, versus Moody against Steggles, which is the pub case, a lot of you would have said, what the hell is the difference? And you won't be wrong, you know, right? You won't be tremendously wrong. Academics have battled over this for years and years. What is the difference between Moody and Steggles and Hill and Tupper? I mean, a lot of them have come up with differences, but I suspect it is always the ex post facto differences, you know, right? So, yeah, if you are thinking what is the difference, some academics have said it could just be that public policy dictates that one person should not have exclusive rights over a river. The law, the courts maybe were reluctant to give this guy the right to park his boats there, which effectively would mean that he kind of controls that part of the river. No one else can go past without him if his boats are there. The courts may have been reluctant to do that. That's a public waterway, public river, right? Likewise, in Wright against Macadam, the fact that the easement of storage was accepted when the facts were very similar to other cases where it was not accepted could be attributed to protecting a vulnerable tenant against a powerful landlord. So again, ladies and gentlemen, what this last paragraph here is trying to say is there is this unwritten rule of what the courts will consider also. They will consider all surrounding circumstances as well. So if you read the case of Wright against Macadam, remember I gave you a few cases just now. Copeland against Greenhalgh. What is the other one? Copeland against Greenhalgh. Grigsby against Melville. Both these cases, it was not allowed. The facts are very similar to Wright against Macadam. In Wright against Macadam, it was allowed. The facts indicate that here, the judges were trying to protect a vulnerable tenant against a powerful landlord. Right? So don't forget that the courts also can apply these external factors as well. Public policy. Now, the good news is this public policy thing won't be tested so much in your exam. I mean, I think it's going to be difficult to test on something like that. But watch out for it. If the examiner is clearly hinting towards one of the parties being very bad and the other party being bullied by the other party, maybe then the public policy may come in, right? The public policy may creep in, right? But I have not seen an exam question like that. I think that would be really difficult. That would be too unfair, too uncertain in your exam answer. But keep in mind, that is also something that can be considered. Are we good? Okay, ladies and gentlemen, if we are all good and there are no questions, we are done with the 4 requirements of Re-Allenborough Park. This is only half of the chapter. We now move on to the creation and acquisition of the easement. Okay? Now, before we do that, I want to sort of, I want to ask you to take this down. It's just generally an overview of what we are going to learn next, right? I think sometimes it's easier if you can see the whole picture first. I have put down the notes in the form of a table, right? But I want to just draw out this chart so that you can see the entire chapter first, right? So just take this down. Or it will be saved in your videos. You can take a look at it, right? Now, my handwriting is definitely better than this, I promise you. But this device makes it a bit difficult to write. Acquisition of an easement. The express. Maybe just take a look at it first so that you can structure it more beautifully in your notes. Can be implied. Right? As you know this, right? The acquisition can be express, it can be implied. If it's express, it can be legal. It can be equitable. And as our discussion in the beginning part of this class, you know how it is going to be legal. You know how it's going to be equitable, right? How is it going to be legal? If it was created by deed plus registration. Equitable, well, either one of those two or both are not there, but at least in writing, according to section 2 of the LPMPA, right? Now, I told you this express part of the creating of an easement is not the superstar of this chapter. Nobody's going to test you on that. Everybody's going to take a look at implied easements, right? So when we take a look at implied easements, okay, it can be implied by way of reservation. It can be implied by way of grant. Now, I will explain what these are. These are very important concepts that you must learn as well. Reservation or grant, right? Reservation, there are 2 ways to do this. Necessity and common intention. If it's grant, ladies and gentlemen, there are 4 ways of doing this. Necessity, common intention, the rule, Again, if you are finding all of this too difficult to follow because of my handwriting, it's all there in the table, right? I'm just putting it in a different pictorial form so that you can see it, and then we are going to look at the table anyway. The rule in Wheeldon against Burrows, and then lastly, section 62 of the LPA 1925. This is what we're going to be learning after this, right? So effectively, you will notice that it overlaps, isn't it? Necessity and common intention is for reservation, and then necessity and common intention is also for grant. So effectively, we're going to learn four things only after this. What does necessity mean? What does common intention mean? What is the rule in Wheeldon against Burrows? What does section 62 do? You understand what I mean? Right? Now, the first thing we're going to learn is, what is reservation and what is grant? In what circumstance is it a reservation? In what circumstance is it a grant? Because you can't get that wrong, because reservation, if it is a reservation situation, you can only imply the easement two ways. But if it's a grant situation, then you've got four ways of implying the easement. So you shouldn't get that wrong, obviously, right? But then your end result will be wrong as well. Now, before we get into all of that, I just want to explain, what does it mean when I say you are implying the easement, right? Sometimes, so let me draw this timeline first. Okay, so let's say, for example, here, the sale took place. So maybe I'll draw this out as well. This is just a generic example, right? So Mr. A owns both pieces of land. Mr. A stayed here, and Mr. A used to walk across this land as a shortcut to the shops. Now, Mr. A has sold this land to B. Right? Mr. A has sold this land to B. So B is now living here. B wants to walk across the land to the shops. But A never granted B an easement. So now B must argue that he must argue that the easement can be implied in his favor. Now, that's what was the previous slide all about. Those are the methods. Those are the things that he needs to imply. So if it is by necessity, he will have to go and argue necessity. Then we are going to learn what are the requirements of necessity. If it is common intention, we are going to learn what are the requirements of common intention, so on and so forth. But in terms of what exactly implying an easement will do, this is what happens. So remember, at the point of sale, when A sold to B, this is the sale. But at the point of sale, there was no express grant of the easement. So B goes to court, and B argues that he is supposed to get an easement. If he is successful, see, this is what actually is happening. If he is successful, what the courts will do is, the courts will imply the easement into the sale. They will imply the easement into the sale. That means it is as if that at the point of the sale, that easement was granted to B. Right? Now, when we do implied easements, this is what we are doing. You're going to court, you successfully argue that there should be an easement implied in my favor. And if it is, you see, an easement can't just exist. It needs to be somewhere. So the courts, what they will do is, they will imply it into the sale and purchase agreement. Because there was no separate agreement signed. So the courts imply it into the sale and purchase agreement. Now, if it was not sale, it was a lease. Let's say, for example, A leased it to B. Can also, the courts will imply it into the lease agreement. Right? So, ladies and gentlemen, this is what's happening. I need you to understand this. Because once again, we are going to get into the nitty-gritty of what is Section 62 and what is Wheeldon against Burrows, and it becomes unnecessarily technical. Right? Sometimes when it becomes so technical and we go so deep, we forget the big picture of what exactly are we doing. It's actually very simple. You are going to the court and you're saying, hey, A didn't give me an easement. I asked him for it now. He doesn't want to give me, dirty fella. So I'm coming to you. Please imply the easement for me. Now you are thinking, why? Why should the courts imply the easement for you? If the owner of the land doesn't want to give you the easement, then it just should be that, isn't it? You're right. You're right. That is why the requirements to imply this easement is actually quite high. And that's why it's also unnecessarily technical. Right? It's quite high. It's not going to be easily given. It's not like, oh, I want a shortcut to go to the shops. Please give me the easement on my neighbor's land. The courts are not going to simply give it to you. So if you satisfy all the requirements of either one of those things, then you get the easement. Are we okay? Okay, good. Now, let's go back to the notes. Okay, firstly, what is a grant, or when is it a grant situation and when is it a reservation situation, right? To make this easy, right, I'll tell you when is it a reservation situation, because there's only one reservation situation. All other situations are grants. If you understand this, it's fairly simple. There's only one situation where it is reservation. So I'm just going to use the word here. Reservation. The reservation situation, ladies and gentlemen, is like this. A owns both pieces of land. Now, quite different from the example I gave earlier. See whether you can spot the difference. A owns both pieces of land. A stays on this land, just like the earlier example. So far, all the examples are exactly the same. Then, the difference is now A sells this land. A sells this land to B. Now, A wants to continue walking on this land as a shortcut to the shops. This is a reservation situation. So let me put it down in words. A reservation situation, it's not in your notes, so you might want to take it down. A reservation is where someone is trying to imply an easement on land that he has just sold or leased off. If you are trying to get an easement, you're trying to imply an easement for yourself on land that you have just sold. The word just is important, that you have just sold or just leased. That, ladies and gentlemen, is a reservation situation. And that is the only situation of reservation. I repeat, where someone is claiming for an easement on land that he has just sold or leased. That is reservation. All other circumstances is grant. All other circumstances is grant. Are we good? Now, I just realized I was supposed to give another break now. Do we need it? Silly question, huh? Okay, let's take a short break, right? Not at full 10, huh? Let's do a 5-minute, then we come back, right? I need everyone to be awake for this, right? So I've just shown you what is reservation. We take a quick break. Just do like a toilet break, and then we come back, and then we start. So 9:34, can we come back by 9:40? Right? 9:40 we'll start. Okay. It is 9:40. So I said 9:40, right? So that's reservation, right? Everything else is grant. Now, this is an important concept. So I'm going to give you some examples and you tell me whether it's reservation or grant. Remember, the trick is there is only one reservation. If it is that, then it's reservation. If it is not that, it's grant. Okay? Okay. A owns both pieces of land. A sells this to B. Now B wants the right to walk across A's land. Reservation or grant? B wants the right to walk. So B is claiming. Remember what I told you about reservation. B is claiming. This is grant or reservation? Grant, right? How would it have been reservation? A sold this land to B, and now it is A that wants the right to walk across the land. This is reservation. Remember, the key here is reservation is where the person that has just sold the land, is asking for a right on the land that he has just sold or just leased out. Do you understand what I mean? That is reservation. Also, another trick is the new guy that's coming into the story, if he is asking for the implied easement, chances are it is grant. See, like B. A is the guy that owned the land previously and then he sold the land and now he's asking for a right on the land that he has just sold. That's reservation. The first example is grant. Why? Because who is claiming for the easement? It's not the guy that previously owned the land. It's B. B is claiming for the easement, isn't it? B is, that's a grant situation. Right? So now, the danger of just memorizing this is, what if the facts are exactly the same? Huh? Let me change this a little bit. So remember, what did I tell you? This was grant, right? This was grant. Exact facts. Huh? A owned both pieces of land. A sold this land to B. And now A wants to continue walking over this land. What is this? A originally owned both pieces of land. A sold this land to B. And now A, from this land, wants an easement to walk across the first land. What is that? Reservation, isn't it? Reservation. Okay, let me change the facts a little bit. Again, in the entire lecture, I have been nicely drawing two boxes owned by Mr. A and Mr. B, right? Exam questions may not come out that way. Let me give you an exam scenario. This is a big estate owned by Oliver. Oliver lives in the big house. And then there is a small cottage. There's a small cottage that Oliver used as an office. That's an important part of the facts. Huh? Oliver used as an office. So there is a pathway from the house to the cottage, and then that pathway goes through the house and out to the main road. Right? Out to the main road. Okay? Now, Oliver leases this to Fred. The cottage. Oliver leases the cottage to Fred. Fred now wants to use the path through the garden, through the house to get to the main road. Grant or reservation? Grant. Simple, right? Not too difficult. Right? Okay. Let me add on to the story. The cottage had a garden. So when Fred leased the cottage, he also got the garden. Okay? It's one package, the cottage and the garden. Now, Oliver wants to continue using the garden for some reason. This is a reservation. Okay, great. I think you all got a hang of it. Fairly simple, right? It's simple, but it's absolutely vital. Because remember, I told you, reservation, there are two methods. Grant, there are four methods. If you get it wrong, you may not use the correct method. Reservation, you can only use necessity or common intention. Okay, now that we've cleared reservation, grant type situation, now let's try and understand what are the methods, right? Okay, so express creation, like I said, don't worry about it. Express grant, express reservation is the same thing. You create it by deed plus registration. It becomes legal. There's a chart below. I've put a chart right at the bottom. In fact, it's actually the cut and paste from the chart I gave you in the chapter of registration. How to create legal easement, how to create equitable easement. All this already is here. Okay? Now, so forget about express. Let's get to implied. Right? Let's get to implied. So implied, first let's look at grant. The first method to imply an easement, to imply a grant, is necessity. Ladies and gentlemen, this is very important. Necessity, there's an absolutely very high standard to achieve. So what is necessity is this. You are arguing to the court that without that easement, I cannot use my land. Without that easement, my land is rendered useless. That is necessity. So a very quick example before we get into the cases. And this is that example that I gave you earlier, right? I mean, I need you to suspend your belief for a while. Suspend reality. Just follow my example. So Mr. A owns this land. But, all around him, he's got other lands. And owned by different people. So Mr. A has just bought this land. Mr. A is not very smart. He bought the land, and now he realizes there's no way for him to get into the land or get out of the land without going on someone else's land. Right? Maybe to make it more realistic, let's just say this. A used to own this land also. That makes a bit more sense, right? A used to own this land also. So he used to walk over his own land to his house. But A, like I said, not very smart. He has sold this land to B. And now suddenly he has become landlocked. Ladies and gentlemen, there is literally no way to get out of the land and no way to get to the land without walking onto someone else's land. Mr. A has gone to talk to all his neighbors. None of his neighbors want to give him permission. He is left with no choice. He goes to court. to imply an easement in his favor. In this situation, it is going to be necessity. Right? Now, necessity, ladies and gentlemen, is a very high standard. Huh? It must be the case that the land cannot be used at all. The land is rendered useless without the easement. Then the courts will grant necessity. If it is just a case where it makes your life easier, if it is just the case that it makes your life, it's just more convenient for you if you have the easement, the courts are not going to grant that easement by way of necessity, at least. Remember, I told you this earlier, right? The courts are always mindful that if they grant you the easement, they are not just helping you, no, they are burdening another land. Right? So you cannot be arguing in your head, that's not fair, just give me law. What is the point? They help you, they are burdening another land. So they have to balance that out. Okay? So let's look at some cases. Wong against Beaumont. Now, Wong against Beaumont, interesting case. Huh? So there was a building, and the building had a basement. Mr. Wong rented out the basement for the purpose of a restaurant. What happens in a restaurant? Cooking. What happens when there's cooking? Smoke. Where does the smoke go? When it's an underground building. I mean, it's an underground space. So you need a chimney, right? And the problem is this. Although Mr. Wong had rented out the space does not give him the right to use the... That's my clouds, huh? That's my smoke. It does not give him the right to use the chimney. So now Mr. Wong is arguing, look, I rented this space as a restaurant. If you don't give me permission to use the chimney, the space is rendered useless for the purpose I rented it for. And the building management, the owner of the building, knew that it was being rented for a restaurant. So that is not a surprise. In this situation, ladies and gentlemen, it was held to be necessity. Right? Remember, it's an extremely high standard that land cannot be used. Okay? Now, this is a positive case where it was successful. I'm going to show you two more cases where it was not successful, and you will see how high the standards are. Re-MRA engineering. Now, in re-MRA engineering, the guy owned a piece of land, but there was no pathway for him to drive his car all the way to his land. He has to park the car far away, I mean, relatively far away, and then walk. There is a walkway to his house, but he cannot drive his car all the way to his house. So he is asking for an easement to drive his car over his neighbor's land to his house. Now, you must imagine that all the negotiations have already done. He tried to ask his neighbor, and his neighbor said no. Or more likely, the neighbor would have allowed, and then now they are fighting, and the neighbor says now cannot anymore. So now he's going to court, right? He's going to court, and he's arguing that I have no other way for me to drive my car all the way to my house. The court said it's okay, it's fine. You park your car far away and you walk. Because you still can use your land for the purpose that it is supposed to be there. Your land is a residence, right? You don't have to drive your car all the way to your residence. You park it far away and you walk. Because the walking part is not walking on anyone else's land. It is walking on land that he is permitted to walk on. See, the principle here is just because it may make your life a little bit easier or it is more convenient, the courts are not going to imply the easement in your favor, especially under necessity. They are not. Manjang against Drame is another case where I think really illustrates this. the only way for the guy to reach his land is by way of a boat. Right? He wants an easement to use his neighbor's land so that he can drive his car over his neighbor's land to his house. Because apart from driving or walking on your neighbor's land, the only other way for him to reach his land is by boat over a river. What did the court say? The court said, use the boat. Use the river. You still can get to your land without the need for this easement. We're not going to give you the easement. Okay, ladies and gentlemen. Right? So I want you to remember Manjang against Drame and MRA Engineering. These cases, I think, stand for the proposition, or at least these cases illustrate how high a standard it will take for the courts to imply an easement by way of necessity. Right? Now, guys, although here technically I am doing necessity under grant, it's the same concept for necessity under reservation. Right? See, I'm just going to push the chart down a little bit. When it comes to reservation, it's still necessity. Same concept. It's just a different case. So you remember read dot. Read dot is for reservation necessity. All the other cases is grant, necessity by way, grant by way of necessity. But the concept, the standards are all exactly the same, right? So I repeat, you are only going to get an easement or implied easement by way of necessity, whether for grant or reservation, if it results, if the situation is your land is totally unusable without the easement. Very, very high standard. Next. Common intention. Common intention also is the same. There is common intention for grant and there's common intention for reservation. So what is common intention? Slightly lower standard than necessity, but there are requirements, right? What the courts are going to argue, or what the courts want to see is there some kind of, common intention? Is there some kind of agreement between the dominant tenement owner and the servient tenement owner? Right? Is there some kind of agreement on how the dominant land is supposed to be used? And is this easement necessary for that? I say it again. I'll illustrate it, but I'll say it again. Was there some kind of common intention? Was there some kind of common intention between the parties about how the dominant land was supposed to be used? And is the easement necessary for that use? So I'll give you an example. This is actually the facts of Stafford against Lee. Right? The facts of Stafford against Lee was like this. Right? So A owned both pieces of land. And then what happened was A sold this land to B. Now, when A sold this land to B, it was clearly known between A and B that B was going to build a house here. A knew that this was the purpose why B was buying the land. That is clear, that is not disputed. A knew that this was the purpose for why B was building this land. What do you need when you build a house? Equipment, right? You need trucks, you need your building material, you need your cement mixer. The issue was, how do they get to this land? They couldn't get to this land without going over A's land. Now, this doesn't come under necessity because there was already a house there. He could have stayed in the small house if he wanted to. So that's why this doesn't come under necessity. But the argument here is A knew that this is why B was buying the house. So even though there was no express agreement between the parties, the courts held that because you knew, the courts can even assume that there was some kind of common intention. And the easement was granted by way of common intention. Right? Okay, let's just read this. Whether there was a common intention of the parties that the land granted, this was the land that was granted, should be used in some particular way, and is the grant of the easement necessary to give effect to that intention. And you see what I mean? So the facts of the story here that I gave you is essentially the facts of Stafford against Lee. The land was sold with the intention that the person buying was going to build a house there. And so then the courts argued, if you already knew that that was the intention and the land was sold with that intention in mind, with that purpose in mind, the courts assumed that there is a common intention and the easement was granted. Right? Now, if you read the case of Wong against Beaumont, sometimes in some textbooks, Wong against Beaumont, they will put it under common intention. It would have worked, both necessity and common intention. Why? Because in Wong against Beaumont, remember the facts, the restaurant case, the building owner knew that Mr. Wong was renting out the basement for the purposes of a restaurant. He knew it. So then the courts can come to the conclusion, if you knew that it was for a restaurant, surely you must have known that there must be a way for the smoke to escape. And so there must have been a common intention for you to use the chimney. Now, something to note here, that common intention need not be an express common intention. It need not be that Beaumont Properties and Wong sat down and shook hands and said, yes, I will get to use the chimney. It doesn't have to be that way. As long as there's a common intention on what the land is going to be used for, the easement is needed for that use, the courts will be willing to imply. Do you understand me? Right? So the question you might be asking is, how is this different from necessity? Necessity is just general use of the land. You only get an easement implied by way of necessity if generally the land cannot be used without that easement. Common intention is if they had a common intention for the use of the land and the easement is needed for that common intention, then it comes under common intention. Are we good? Are we okay? Right? So that is common intention, right? Now I want you to take note of this case here, Chaff against Kingsley. Right? Chaff against Kingsley stands for the proposition that, especially for reservation, right? Common intention, reservation by way of common intention. The courts are not going to be so easily granting an easement by way of common intention, especially in a reservation situation. Why? Once again, it goes back to the principle that I told you earlier. The courts are not going to simply be granting easements that burden another piece of land. But the logic is, in a reservation situation, I owned both pieces of land. I was in full control of both pieces of land. I chose to sell that land to you. And then now I'm asking for a right on that land that I just sold to you, isn't it? And I'm asking it by way of common intention. The courts will say, you're just being stupid. I mean, they won't say that, but that's what the courts will think, isn't it? You had full control. You sold the land. You could have included that easement in the sale and purchase agreement if you wanted it. You were in control. Right? You could have insisted, I'm selling that land to you, but I want to continue walking across the land and I'm putting it as a criteria of the sale. It was well within your control. And if you chose not to do that, you cannot come later and say, please help me. Right? So, ladies and gentlemen, you will find that there are not too many cases on common intention, especially with reservation. And there's good reason for that. Chaff against Kingsley, Chaff against Kingsley clearly stands for the proposition that it will not be presumed lightly. The courts will not be, I mean, they won't make it so easy for you. Let's put it that way. Are we good? Reservation, necessity, common intention. These are the ones that are common to both grant and reservation. There is no difference in the principle, whether grant or reservation. The only difference is the cases. It'll be great if you can remember this is the reservation necessity case, or this is the grant necessity case. But if you don't also, it's not a big deal, in my opinion. Right? So the principles are exactly the same. Now we move on to the other two, the ones that are different. The rule in Wheeldon against Burrows, right? And section 62. Now, put a big star next to this. I can almost guarantee you every exam question will test you on the rule in Wheeldon against Burrows and section 62. Now, necessity, common intention is there sometimes, is there not all the time, but I can almost guarantee you Wheeldon and Burrows and 62 will be tested, right? Looking at the time, I think we will have enough time only for Wheeldon. We will continue tomorrow, right? So usually what will happen is I'll do Wheeldon, then you all go home and you'll come back tomorrow still confused, and we'll do Wheeldon again, right? And then we'll do Wheeldon and 62 tomorrow. Anyway, so let's do Wheeldon first. Okay, now let's read the rule first. Just read with me. I mean, I will draw the picture and illustrate it and all of that, but just read the rule with me first, right? When the vendor is the seller, right? When the seller sells part of his land to the claimant, all quasi-easements, so obviously already there is a technical term here that we need to explain, but just follow me on this. All quasi-easements that were previously used by the vendor that benefited the dominant tenement will now become full easements in favor of the dominant tenement, provided the rights were continuous and apparent, and they were necessary for the reasonable enjoyment of the land. So what does that mean? I always make it a point to read it with my students. Isn't this, I mean, what the hell is going on here? Any clue? The point I'm trying to make here is, again, this is an unnecessarily archaic, old-fashioned rule, right? It's one of those, and this is not unique in English land law, right? How many of you sometimes feel that English land law, like for example, freehold covenants? You've done freehold covenants, right? The rules of passing of burdens and benefits in common law and passing of burden and benefits in equity. It seems like random people made up the rules at different times and they didn't talk to each other, isn't it? You know why it feels like that? Because that's exactly what happened. It's entirely judge-made law, isn't it? Same thing here. Right? It's like, imagine a rule of rules of a game, but different people in different countries made up the rules randomly without talking to each other. Then they chucked it all together as one rule book for this game. So that's what easements is. If you think, wow, what a silly set of rules, it's ripe for reform, you're right, it is. In fact, the Law Commission report that published in 2008 also recommends reform. The same Law Commission report that you would have read for freehold covenants, right? In fact, that commission report is easements, freehold covenants, and profits, right? They recommended a whole bunch of reform, mostly for freehold covenants, but they also recommended reform in this area. So why am I telling you this first? If you are going through this area of the law thinking, what the hell, what kind of rule is this? You are not wrong. Right? You are not alone in thinking that this is a ridiculous set of rules. Having said that, let's learn the rules, right? Okay, so Simply put, the rule in Wheeldon against Burrows is like this. Okay. Let's flash back to the first part of this lecture. One of the important criteria for an easement is there must be a dominant tenement and there must be a servient tenement. Secondly, there must be diversity of ownership or occupation. So in this situation, ladies and gentlemen, when Mr. A lives there in this house, and then he walks across the land because it's a shortcut to go to the shops, can this be an easement? No, it cannot. Why? Same owner. Very good. Apart from the absolutely logical reason of, what the hell, you can't get an easement on your own land, right? But if you want to get technical and go according to the rules, you're right. There is no diversity of ownership or occupation. But ladies and gentlemen, this satisfies all the other criteria for an easement. This is what we call a quasi-easement. I mean, again, forget about law for a while, just basic English. Quasi. Quasi means what? Almost there, right? It's not full, but it's partial. Quasi is partial. So another way of saying it is a partial easement. Now, again, there's no such thing as a partial easement. It's an easement or it is not. Okay? But this term quasi-easement is given specifically for a situation where that right satisfies all the other requirements of an easement, except that there's no diversity of ownership or occupation. Are we okay? Now, I know I'm reiterating, I'm saying this again, but I think it's important. It's worth saying again. There is no middle category of easements. It's either an easement or it is not an easement. This quasi-easement is just a term that we use to identify rights that are in this specific situation. Okay, so let's read that again. When the vendor sells part of his land, the dominant tenement. So the vendor here is A. A is the fellow who's selling the land, right? So when A sells the land to B, when the vendor sells part of his land to the claimant, so the claimant here is B. All quasi-easements. So this is a quasi-easement. Not just any quasi-easement. So this is one requirement. All quasi-easements, right, that were previously used by the vendor. That's an important element as well. A must have been actively using this right. If he was actively using this right, meaning he was walking across the land every time before he sold the land. Okay? All quasi-easements that were previously used by the vendor, benefiting the dominant tenement, will now become full easements in favor of the new dominant tenement owner. So long story short is, when B bought this land, and now B is staying in this house, B also now wants to use the shortcut to go to the shops. But A, who still owns this land, A never granted it to B. So B has to now claim the rule in Wheeldon against Burrows. And if he is successful in claiming the rule in Wheeldon against Burrows, this right will become an easement in favor of B. How? Again, don't worry, we'll do this again and again until we get it, right? But so that's the preliminary stuff first. Then there are some provisos, there are some conditions. What are the conditions? The conditions are, number one, the right must be continuous and apparent. So what we're talking about, this right here, the right to walk across the land, or it can be any right, remember? But that right that you are claiming must be continuous and apparent. So what does continuous mean? It must have been continuously used by the seller, by A. So what is the definition of continuous? It doesn't need to have been used every day, but it just must be regularly used in a reasonable way. So if it is a right that is used once a week, as long as he used it once a week, it's fine. But also, if it is a right that is used once a year, as long as it is used once a year, every year, it's continuous. But it must be a right that is normally used once a year. So there was one exam question. The right that they were talking about is the right to underground piping for water, right? The water pipe, the underground pipe goes under the neighbor's land. The owner previously was using that pipe. Then he sold the land to the new guy. The thing is, that pipe is only used for 3 months a year during the summer months. Because in summer, it gets very hot, very dry, the river dries out. So they need the pipe. But during all the other months, they don't need to use it. So the right is just used 3 months a year. But it's used 3 months a year every year. Does that count as continuous? Yes. Right? So it must be continuous and it must be apparent. What does apparent mean? Apparent means it needs to be clear. It's not something in hiding. It cannot be a right that is used in secret. So the right to walk across the land, it's being done in the open, right? So it will be apparent. Right? And don't forget, necessary for the reasonable enjoyment of the land. Now, don't let the word necessary here throw you off. This necessary is not the same as necessity that we learned earlier. Here it's just, does it make your life easier? That's it. Does it make your life more comfortable? That's the test. That's it. Right? So, coming back to the example that I gave you, the picture that I drew out in the side here. So now, in this scenario, this is your typical exam question, right? B has bought the land now, and B wants to continue walking across the land to the shops. You are asked to advise B. You have to look at this scenario, and you have to know that this is a Wheeldon and Burrows scenario. See, that's the tricky thing, It may not seem so tricky now, because you haven't learned 62 yet. When you take a look at 62 tomorrow, and don't worry, tomorrow when we come, I promise you, when you are fresher, we will do Wheeldon again. I will do Wheeldon again tomorrow, okay? It is tricky, it is tricky, right? But when you see 62, you will see that Wheeldon and 62 sometimes apply in circumstances that are incredibly similar. This is what I meant in the beginning of the class when I said it is tricky. Right? But it's still a chapter that I'll advise you to do, honestly, my opinion. Right? But okay. So you are advising B. You've seen the scenario. By the time you go to your exam, you would have had enough practice. When you look at this scenario, you will immediately know this is a Wheeldon situation. Then you apply Wheeldon. You will say, look, B wants to continue walking across the land. He can, if he can argue that he comes under the rule in Wheeldon against Burrows. So, what is the rule? Where the seller of the land, A, right? When A sold the land to B, all quasi-easements, were there quasi-easements? Yes, there were. because A was walking across the land. When A owned both pieces of land, A was walking across the land. That's a quasi-easement. So when A sold the land to B, all quasi-easements that were previously used by the seller, that's also important. That's also something that you must discuss. All quasi-easements, that's one thing to discuss. Is it a quasi-easement? That were previously used by the seller, that's also something else to discuss, will be converted into full easements in favor of the buyer. So it's actually, that's it. I've used simpler language. I'm saying it again. When the seller sells the dominant land to the buyer gets all quasi-easements that the seller was previously using, provided it is continuous and apparent and necessary for the reasonable enjoyment of the land. Right? Okay. This is where I'm going to stop today. We're going to come back tomorrow and we're going to look at these few cases that kind of explain it a little bit. But you have essentially learned the rule, right? You've learned the rule already, right? This is the rule in Wheeldon against Burrows, right? So tomorrow, like I said, we will start with Wheeldon and Burrows. We will go on to 62, and then we're done. The chapter is effectively done, right? So I don't expect this to take long. I think it'll take 45 minutes, maybe an hour. Then for the remaining 2.5 hours, we'll look at questions. Are we okay? Okay, thank you very much. I'll see you all tomorrow at 7.